the testimony that was presented, the court simply cannot. The entire premise of DPS's argument starts with Mr. Hackbarth being wrong. And in order for you to uphold probable cause, you would have to make such a finding. But there's no evidence in the record. So I'll make an offer of proof as to Mr. Hackbarth's testimony being consistent what it twice already was on September 3rd and September 2nd. So now we have disputed facts. Then there's the issue of Luke Hague. The detective could not answer various questions. Once again, I'm renewing my offer of proof as I did at the last hearing, and you invited me to renew. That would be concerning precisely what he did, the lack of identifiable characteristics on the evidence bullets, on the bullets that were recovered from the vehicle. The fact that the Escalade fragments were not even testable. They were in such bad condition, yet DPS found a match. That's significant. The ATF issue, we don't have those. The state still has not complied with our request for production, and obviously it was, pending today's hearing was the state's position. Then there's the issue of...
Your Honor, just for the record, I'm not the state for the purposes of this.
I'm sorry.
He's said it a number of times, but I don't want the record to be confused, that this is not the state that's making this argument. It is on behalf of DPS and the affiant, Trevor Graff. So just so the record's clear.
Okay. And noted, this is the Department of Public Safety, and that's who Mr. Vigil's representing. So the issue then becomes, what did ATF do? They have not provided us that information. Again, as the witness said, you need to talk to ATF. These are all things that negate probable cause. These are all things that were consciously and deliberately omitted from the affidavit, in addition to the pawn shop. These are all subjective value judgments that the detective made in depriving you of an opportunity to look at all of the evidence. You've heard about the BMW technician, the fact that the tire would lose air. I'm not going to rehash everything. Those are all offers of proof. And then again, John Dawes, DAWS, the defense tire expert, and the court, I think, could take judicial notice of Dr. Dawes' report that was filed in CR 2015-144211. It is in the record. It was appended to our motion to modify release conditions. I don't know if the court independently recalls it. These are all offers of proof that we wish to make. If the court does not find, based on today's testimony alone, that there is no probable cause. If the court is inclined to make any other finding other than that there is no probable cause, then we wish to put on these witnesses, because these are the individuals whose testimony and evidence will negate what was presented in the affidavit. So if there is a disputed issue of fact, then we would like to further put on evidence, as the court invited us to do, if we get to such a point. So with that, a summary ruling in Mr. Merritt's favor will end all that right now. And under the syllogism that the detective testified to, that's the only proper ruling.
Vigil.
Your Honor, the burden is on, in this case, Mr. Merritt, to prove that there is no probable cause. The affidavit was given to you. All of the facts that were known to the affiant, Trevor Graff, were presented to you at the time the affidavit was given. And no, he didn't attach the full reports or write the full report of Trevor Graff or ATF in the report, but it is telling that he gave you those conclusions. He gave you the conclusion of Lucian Hague, who said that it was insufficient to constitute an identification, and what you heard today was that not only did he say that, but he said that he could neither exclude or identify. He couldn't exclude it or include it. So that was presented to you. What was presented to you at the time the affidavit was given to you also was that the ATF reached that same conclusion, that it was insufficient. And we have the findings of the DPS criminalists who found beforehand that the gun matched, and then with the new testing that the gun matched, the bullets. Those are all facts that are still in front of you that are not disputed, and I think what Mr. Lamb is asking for is to blow this whole thing wide open, to test the methodologies of the criminalists, to have Lucian Hague come in here and give all of his testimony about how it was done, how he came to the conclusions of insufficiency of evidence, that they were not included or excluded, and to have the ATF do the same thing. Those having them come in and testify is not going to change their conclusions, which were could not include or exclude, and it's not going to change the conclusions of the DPS criminalists who found that they were indeed a match. And yes, they said 100% match. And you heard the affiant Trevor Graff testify that based on his knowledge, that was the information he had. The only thing that Detective Graff changed during his testimony today was that the bullet from the BMW was not tested immediately with the other three. Rather, that was done a couple of days later. But the conclusion that was reached was still the same, that they all matched. So, Your Honor, I don't think that a determination, at this point in time, Mr. Merritt has not met his burden of proof to show that there was no probable cause to support the affidavit, and we would ask the court to maintain the search warrant and reaffirm its decision.
Mr. Lamb.
Judge, what DPS ignores is the collective knowledge doctrine. Everything that was in the possession or constructive possession of the state and its agents at the time of the warrant on June 27th is imputable to Detective Graff. Now,
Mr. Lamb, at that time, though, the case was in the control, my word, of the county attorney's office rather than DPS?
I disagree, Your Honor, respectfully. This is June 27th. The motion to dismiss was filed April 19th, 2015. Your Honor granted that motion 3 days later.
The portion of the case where it was a pending case in the hands of the county attorney's office, it was the county attorney determination to do the Lucian Hague retention. Is that fair to say?
It is fair. However, that report is in the DPS file. In fact, I know that DPS, through its public information officer, did a dump of about 1,500 pages of records right around July 4th, and there were references to Mr. Hague in there, to the best of my recollection. So clearly they had knowledge, and just like we deal with Carpenter in criminal cases, how the detective is the agent of the prosecutor. Well, it actually flows in the converse as well in this particular case. So I believe that the state of Arizona, through DPS or the county attorney's office, is one fluid entity when it comes to the collective knowledge doctrine, particularly when they are sharing information, and I believe that was the case here. So I think to suggest otherwise would respectfully reduce Detective Graff to an ostrich who buried his head in the sand. And I'm not saying he would do that, but it's very conceivable then that a chain of command would tell him, hey, go do this, but put on blinders and forget about everything else because we're not going to tell you. That's just implausible from a perspective of fundamental fairness. Now, with regard to Mr. Hague, there seems to be a concession that his full opinion was not presented. And even if it's simply an inconclusive, anything less than a 100% match, which is what the DPS crime lab found, is exculpatory. And any portion of his opinion that is exculpatory and was left out negates probable cause. With regard to the new testing that DPS did, it was actually Luke Hague's testing. Judge, his report was dated April 14, 2016. His study was published 11 days later. Don't you think that Mr. Hague would have done this testing with the 357 bullets himself 11 days prior? I submit to you that it was done concurrently in the publication. It's a logical inference that it took a week or so for that to happen. Wouldn't Mr. Hague have done that himself? Of course he would have. He's the one who developed it.
Well, if I accept your prior premise, what information do you have that Detective Graff was aware of Lucian Hague's second study?
Because the crime lab, well, his affidavit says so, quite frankly, because the crime lab did the testing based on Luke Hague's April 27 study. In other words, that's what they grasped onto, and maybe we didn't make it clear in the record, and I invite counsel or the detective to chime in if I'm mistaken in any way. the new testing with the 357 rounds.
Now, Mr. Vigil is standing, so he wants to say something.
I just want to find out if I understand what Mr. Lamb is saying. Is he, and I guess I can talk directly to Mr. Lamb, are you indicating that Lucian Haig actually conducted a different testing with the new study, or just that he formulated that new study? Because I am not aware of any testing done by Lucian Haig as it pertains to his new study.
And that's precisely why we needed his notes, and that was the subpoena that the court provisionally quashed without prejudice. That's exactly what I was looking for, Judge. But logically, if he's doing the study concurrently at the same time as Mr. Merritt's gun, you would think that he would be applying to the study, to the work that he's doing on behalf of the county attorney's office. So yes, I do believe that Detective Graff was aware. In fact, I know he was aware because his affidavit says so when he talked about the study in his affidavit, and he talked about it on the witness stand. But that testing, it amplifies the controls. It doesn't amplify the unknowns. If we have minimal striations that are insufficient for comparison on the unknowns, the new testing doesn't change anything. It only bumps up the controls. Again, that's something that we are making an offer of proof that we would get into with Mr. Haig. Same thing, I'll renew the offer of proof with Dr. Dawes. And again, if the court is inclined to in any way find that there's probable cause, then the court must be making an assumption that Mr. Hackbar is wrong. But there's nothing in the record to support that. As the detective said, if the crime lab's right, then Mr. BMW driver must be wrong. But conversely, if he's right, then the crime lab's wrong. So that's a disputed issue of fact. And if the court is going to make a finding that he's wrong, then the court would need to hear testimony from him in that regard. The court does not have that before. But as we sit here, we don't believe there's probable cause. We'd ask you to enter an order accordingly.
The court believes that under its 3922 analysis, it must look to the four corners of the affidavit to determine whether it's more than not that the gun was a proper subject of seizure. With respect to the four corners analysis, it does, I think, allow for a prospect of what the affiant knew or should have known in drafting the four corners of the affidavit. The court finds that based upon the affidavit, it was probable cause to believe that there had been a shooting at an Escalade on August 29th at about 11:03. There had been a shooting at a motor bus on August 29th at about 11:05. There had been a shooting at a Kia about 10:15 on August 29th. There had been a shooting at a BMW on August 30th about 9:45 p.m. The affidavit reflects that DPS on two different occasions did analysis of comparing fragments or shells or casings found at the Escalade against a known, found the motor bus against the known, found in the Kia against the known, found against from the BMW against the known, and in each instance found that the known matched the suspect shell or fragment, and that the known came from the handgun that was seized subject to the search warrant. The affidavit makes it clear, not as clear as defense would have it, that Mr. Haig comes to a different conclusion with respect to each of those decisions. ATF comes to a different conclusion as to each of those decisions. And that the victim in the fourth shooting provided information inconsistent with that conclusion. The court does not believe that 3922 is intended as a mini trial. So taking at face value the affidavit, the court does not find any material omission that would have changed the court's mind if it was, even if we carved out the fourth shooting. So based upon that, the court will deny the motion to controvert, not to invite issues, but I did make a comment about this last time under the Salerno case, the ability for the law enforcement to keep the property of another is not without limitations. So, anything else, Mr. Vigil?
No, Your Honor.
Judge, in light of the Salerno case, effectively the court's order allows for an open-ended seizure of the property. What limitations?
Well, the state may first say that, I think what I read the state Salerno case to say is they can't just rely on the 7 years statute of limitations.
Correct.
But other than that, I think it's based upon the certain circumstances of the case as to whether charges are going to be filed, and if not, when that decision can be made. If so, even if filed, is there a need to keep the gun?
And we'd ask the court to enter a specific order as to how long that weapon can be held, because the court's respectfully inviting the same sort of problem that the Salerno court condemned.
I have no factual basis to know what's going on to make any timetable.
And I have none, Your Honor, as to what the state would be doing as far as the prosecution goes.
I recognize there's lots of moving parts on that decision. None of them are here.
Would it be appropriate to revisit that on a date certain?
Again, I don't have any factual basis to throw a dart at the calendar. If there's a specific motion, again, not to to invite issues, but if there becomes a reason to file something, you can file it.
And lastly, Your Honor, with respect to the court's ruling, is the court rejecting the offers of proof made by the defense, summarily denying them, or precluding us from presenting that testimony?
I would accept them as the proffer with respect to Mr. Haig's report, with respect to the victim's statements in both interviews, with respect to the ATF report. The others I find not relevant.
The tire expert, is the court saying it does not find relevant in this case?
Because I don't think the tire expert, in my mind, touches the timing issue.
Okay. And the BMW technician and the related service records?
Well, again, I'd accept that information in terms of how it works, but it's not conclusive on the timing issue.
That's all we have. Thank you.
Thank you. We are adjourned. Back.
And, Your Honor, not in relation to this, but in relation to Mr. Gibson, I will be available by phone on September 1st.
You will?
Yeah, I have something, I have a conflicting meetings, but I will be available.
Your pleading did not calm his savage breast.
I didn't think it would, Your Honor.